Hello, I am so excited to share with you today the following presentation from the Cancer Legal Resource Center, Know Your Rights, Workplace Rights and Accommodations. My name is Shelley Rosenfeld, and I'm Director of the Cancer Legal Resource Center. Although I am a lawyer, today's presentation is not legal advice. This presentation also does not establish an attorney-client relationship. This is the Cancer Legal Resource Center, and we are a program of the Disability Rights Legal Center. This webinar is a part of a wonderful series called Know Your Rights. It is sponsored by the generous support of CGen, and we have already had several webinars, and including today's, they will be available on the CLRC's YouTube page. We have two more after this. We hope you'll sign up. Even if you're not sure if you can attend, it's worth it to sign up just in case, so it's on your calendar. And you don't have to watch each webinar in order. You can watch in any order that you want. So we're covering really important topics, and they are important for you to know your rights. So the Cancer Legal Resource Center, or CLRC, is a program of the Disability Rights Legal Center. It's a 501c3 nonprofit based in Los Angeles, California. We help people nationwide. We are an educational model and will do intakes in English and Spanish. We also have a language line for speakers of other languages. All of our services are confidential. So people often ask, what does cancer have to do with the law? This is a list of some cancer-related legal issues. Cancer affects the patient, survivor, families, healthcare professionals, and impacts many different areas of the law. If someone has a legal question and is affected by cancer, whether or not the topic is listed here, they can contact the CLRC for more information. And speaking about contacting the CLRC, as you can see on your screen, there is more than one way, but you only have to use one of these ways to contact the CLRC. I'm going to do my best to leave time for questions at the end of the webinar. The question and answer period will not be recorded. This webinar is recorded, but then I pause the recording and I'll take questions at the end. Hopefully I'll be able to answer your questions, but if I'm not sure, or if you have questions that come up down the road, this is the best way to get in touch with us. Either filling out an intake on our website or calling our toll-free number to leave a message for someone to call you back and complete an intake. All the information we provide is free, though we do not provide legal advice or direct representation. Our webinars are always free and cover a wide variety of topics. On your screen is the YouTube link to watch any of our past webinars. This webinar is being recorded, as I had said, so you can definitely take notes during this presentation, but if there's a part that you want to come back, or if you're worried you didn't take down something completely, then not to worry. You can skip to the part of the webinar that you want to rewatch, or you can rewatch the entire webinar. The point is that you have the opportunity to go back and to make sure that you have the information that you need. The CLRC now has a self-help clinic. It is a legal self-help clinic from a generous grant from CGen. And so far, it has been at the City of Hope's Comprehensive Cancer Center. It was actually there last week, most recently. Our plan is to be at UC Irvine's Comprehensive Cancer Center on August 24th. If someone wants the CLRC self-help clinic to come to their cancer patient services center or hospital, they can tell their doctors, their patient navigators about us, and their cancer center can reach out to us to see if something can be arranged in the future. So definitely worth it to share with your cancer center about this wonderful opportunity that's free. The CLRC self-help legal clinic can come to the place of your choosing, potentially, if your cancer center contacts us. So thank you so much to CGen for your support. The CLRC also has a professional panel, which includes attorneys from across the country who help those with cancer if a caller needs help with a matter in their state and practice area. You saw on a previous slide the practice areas that attorneys handle, but just to recap some of them: landlord-tenant, health insurance matters, medical malpractice, estate planning, employment law, and divorce law. It's a minimal commitment. All that the attorney agrees to do is a half-hour consultation. It is very easy to apply and free to apply. The CLRC also maintains a library of fact sheets on a variety of cancer-related legal issues on our website. And it includes a resource called our Patient Legal Handbook. The handbook provides a brief overview of many of the most common issues and questions that people living with cancer and their families have. And we'd like to give a special thanks to the handbook's generous sponsors, the American Cancer Society and Breakaway from Cancer. If you're interested in receiving a large number of copies of our handbook, please submit a bulk order on our website. We also have PDFs of the handbook in English and Spanish available to download for free. So however you want to access our patient legal handbook, it is for free, whether it's online or if it's a bulk order to your cancer patient services office or also doctor's office. Today's presentation will focus on your rights at work. And after we discuss the really important fundamental information, of course, we want someone to avoid losing their job in the first place. So let's start off discussing workplace protections. When someone receives a cancer diagnosis, often this is the first place they may be legally impacted: their job. Our jobs provide us with income and health insurance, so it's important to know your rights in the workplace so you can protect yourself and have the knowledge of how to ask for what you are legally entitled to. I'm going to explain your rights to take off time from work as well as anti-discrimination laws. I'll go over your rights to take medical leave, whether you have a job currently or are wondering about going back to work. I'll talk about anti-discrimination laws that apply to an employee and an interviewee, and what reasonable accommodations are under federal and state laws. So let's look at a case study. Sometimes it's an easy way to see an example and to learn the information. John just found out he needs to have surgery, which means he will have to take time off from work. You can see on your screen some information about John. 60 employees at John's branch, 8 months at his job. He's a full-time bank manager. Now, before we talk a little bit more about John, I'd like to go over some information that will help you make an assessment of whether John has certain rights or whether he doesn't. Now we're going to discuss a federal law called the FMLA. That stands for the Family and Medical Leave Act. It allows qualified employees to take up to 12 weeks of unpaid leave at once or in shorter blocks of days or even a few hours within a 12-month period. The law applies to patients and caregivers of a spouse, child, or parent with a serious health condition. The caregiver and or patient is often required to get medical certification from a healthcare professional stating that the caregiver's services are needed. A person is allowed to take FMLA time off from work to care for themselves or a covered family member. People that qualify as a covered family member are parents or a person acting as a parent, minor children or adult children who are incapable of self-care because of a mental or physical disability, and spouses. As long as a person is a covered family member, a caregiver can take time off from work under FMLA to care for them. Not all employers are covered by this federal law. These are the employers who are covered by this law. Private sector employer with 50 or more employees and 20 or more work weeks in the current or preceding calendar year, including a joint employer or successor in interest to a covered employer. public agency, including a local, state, or federal government agency, regardless of the number of employees it employs, or a public or private elementary or secondary school, regardless of the number of employees it employs. Employees at these companies that I just described must have worked at least 1,250 hours in the past 12 months and must have worked for the employer for at least a total of 12 months in the last 7 years. The 12-month requirement doesn't have been at all at once if someone is a seasonal worker, for example, and 1,250 hours averages to about 24 hours a week. They must also work at a location where the employer has at least 50 employees within 75 miles. If someone is going to take FMLA leave, it is important to talk to their employer about going on leave. The employee must give 30 days advance notice about the need for medical leave. If the employee learns of the need for leave less than 30 days in advance, then they must notify their employer as soon as possible. Once notified, the employer must notify the employee whether they are eligible for leave under the FMLA within 5 business days. Once eligibility is determined, the employer may require the employee to provide medical certification, which in most instances must be provided within 15 calendar days. In a caregiving situation, the caregiver will need to provide medical certification about the person who needs the caregiving. They also may need to include information that is different from what the patient would have to do. The Department of Labor has a separate form for family members. Employers must comply with all applicable laws regarding the confidentiality of medical information. Therefore, the employer must keep the employee's medical information and/or records separate from their personnel files in order to protect their privacy. Here's an important tip. If you ask a general practitioner to complete the medical certification, their letterhead will not say oncology, and you can avoid disclosing the nature of the illness to an employer if you don't wish for them to know. The next definition I'd like to get into is the 12-week period of job and health benefit protected leave under the FMLA. Those 12 weeks of leave can be taken all at once in a 12-week block of time, or in intervals, such as 1 week per month for chemotherapy, or every third Friday off for a doctor's appointment. You may use intermittent leave only when it is medically necessary. The employee must provide a certification by a healthcare provider if the employer requests it. A medical certification would state that working on this different schedule or being able to take leave on an intermittent basis is necessary to provide for treatment or to provide care or provide psychological comfort to a family member with a serious health condition. Employers have to calculate FMLA leave using an increment of time that's no larger than how the employer would use to account for use of other forms of leave. So, for example, if the employer calculates leave in blocks of 3-hour shifts, missing most of one shift will count as missing 3 hours, 3 full hours, that is, but may not count as missing a full day off of work. It is important to know that FMLA may work alongside the American with Disabilities Act for patients. For example, if a patient with cancer took 12 weeks of FMLA leave but was not ready to return to work, additional leave may be granted as a reasonable accommodation under the ADA, especially if a definite end to the leave is clear. So just because someone's used up their sick days and FMLA leave, it doesn't mean that there's no other possible option. There might be. However, taking more time off of work is not always considered a reasonable accommodation, or rather reasonable, and is decided on a case-by-case basis. Unfortunately, because caregivers are not eligible for reasonable accommodations under the ADA, a caregiver could look to their employer's policies or handbook for additional protections, or maybe state laws. And speaking of state laws, FMLA is unpaid. Certain states have paid family leave, so it is important to check with your local government agency to see whether it is an option in your state. Since this is a national webinar, I'm covering, of course, the entire country. The states that do have the program provide partial wage replacement during leave for a limited period of time. These state laws often work in conjunction with FMLA. It is important to note that being entitled to paid family leave doesn't necessarily mean you're entitled to FMLA leave, and some paid family leave programs allow income replacement to take care of family members other than just a parent, spouse, or child. So let's go back to John. So can he take FMLA? Remember, he works full time for an employer of 60 employees in the workplace, and he's been at his job for 8 months. The answer, all right, are you ready? The answer is no, because he's only been at his job for 8 months. You need to be at your job for 12 months. There are 60 employees. So does the employer have to provide FMLA to eligible employees? The answer is yes. 50 or more in a 75-mile radius. They're all in his branch. The employer has to provide FMLA for their employees who have met the requirements. So as you can see, this information has a lot of practical implications. While on FMLA leave, an employee is on unpaid leave, but in some circumstances, an employer may require and an employee has the right to choose to use accrued vacation or paid time off so that he or she gets paid while on FMLA leave. Similarly, an employer may require and an employee has the right to choose to use sick leave when the leave is for the employee's own serious health condition. For example, someone might want to use his sick time while he is out on leave if he has no other source of income. What if you know you'll be out for a while? If you don't qualify for FMLA, in John's case and many others, you're not necessarily out of luck. Or what if you need additional leave time beyond 12 weeks because the 12 weeks is not enough? You might be able to get an extension of leave time. How? Ask for leave time as a reasonable accommodation under the ADA. I'm going to explain what exactly that is. But essentially, if you qualify for ADA protection, you're allowed to ask for accommodations to help you enjoy equal opportunity in employment. For some employers, it may be reasonable to allow you to take some time off under the ADA. Secondly, check your employer handbook to see what your company's policy is on sick leave. Some employers have a very generous medical leave policy. That's generally a good starting point. I'm not going to go over all of the rules for teachers specifically here, but just to note that there are certain specific and additional rules if you work for a local education agency. Just a heads up, you can fill out an intake at clrcintake.org if you have specific follow-up questions about employees of education agencies. So to recap, as the slide says, FMLA, 12 weeks unpaid job and benefit protected leave, 12 months at the job, 1,250 hours in the last year. If not qualified, reasonable accommodation request and employee manual. I think it's important to recognize that although FMLA is unpaid and for someone affected by cancer, income is hugely important to have. I completely understand. The point is that at least the job is held and it protects their job and it protects their benefits, which are hugely important. So while there are some downsides, this law does protect folks for hopefully to be able to return to their job and during that time to keep their benefits. Okay, so hopefully you have an idea of your right to medical leave. Switching gears slightly, let's move to anti-discrimination laws. I mentioned if you can't get FMLA, you can request a reasonable accommodation, so I'll go over that in this section. I'm going to go over job discrimination protection. People with disabilities could not be treated differently in the workplace, even in the interview process. So a lot of people don't know that even before someone has the job, when they're interviewing, they are protected from discrimination. It applies to all phases of employment, job advertisements, recruiting, hiring, firing, layoffs, tenure, compensation, benefits, and all other terms and conditions of employment. I want you to know your rights in the workplace before it's too late. As you know, this is a Know Your Rights webinar, so knowing your rights in the workplace is crucial. Pass along the information to anyone you think might want to know. It's just important to know your rights so that you can exercise them and advocate for yourself to avoid negative consequences, potentially being fired. Unfortunately, people tend to contact us when it's too late. We provide these educational presentations to members of the community as much as possible within the hopes that people stop losing their jobs when that could have been avoided. I'm going to go over the American with Disabilities Act, or ADA. There are state laws as well, so if you need to know your state's anti-discrimination law and whether it covers employers of fewer than 15 people, you can fill out an online intake on the CLRC's website, clrcintake.org. All right. So employers of 15 or more employees have to abide by the ADA. An employee is qualified for protection regardless of how much time you've worked for an employer. So that's a difference. Remember, in FMLA, you have had to work for an employer for a certain amount of time. If you have a qualifying disability, which I'll explain in a second, and if you are a qualified employee, well, what does that mean? Qualified employee means that you can perform the essential functions of your job. If you need reasonable accommodations to help you do the essential functions of your job, you're qualified. Qualified means you can perform the essential functions with or without accommodations. If there's no accommodation that would help you do your job, then you would not be a qualified employee. So, for example, a lawyer with a disability who applies for a carpenter's job isn't going to be qualified because there's no accommodation that could help the attorney be a carpenter, unless they have some training or expertise we don't know about. Okay, so how do you know if you're qualified for ADA protection? We know that you have to be a qualified employee, but you also have to have a disability. It's important to know the definition of disability. Certain laws define it differently. So let's look at the slide. Disability under the ADA, a physical or mental impairment that substantially limits a major life activity. Let's break down the first part of the definition. A physical or mental impairment. What does that mean? Well, let's break it down. If someone is if they currently have a physical or mental impairment. History. If someone was diagnosed with cancer, has completed treatment, is applying for a new job, the person is capable of doing the job, but the employer is treating them differently because of their history with cancer. Regarded as, that's something that a lot of people might not be familiar with. For example, an employer knows of your diagnosis and starts to treat you differently, even though you're still capable of doing your job and you don't have any impairment. So let's say the person has cancer, they're going through treatment, but they actually don't have any impairment. They don't need any accommodations. They're feeling great. Everything's going well. They do have cancer, and a type of cancer. Of course, I use cancer in the general all-encompassing term, but of course, there are many different types of cancers and different stages within each cancer. So just for the purposes of this presentation, I use cancer, but obviously there are so many different types and so many different experiences that people have. So even though the person is still capable of doing their job, they don't have any impairment, that the boss treats them differently just because they know they have cancer. They're regarded as. That's what that phrase means. Caregivers may be entitled to protection from discrimination based on an association with a person with disability. For example, a caregiver is someone with cancer who their boss knows that they are associated with someone with cancer, their caregiver, and then starts to treat the caregiver differently. The physical or mental impairment has to be one that substantially limits a major life activity. These are major life activities, anything you do to take care of yourself. So it is not limited to, but here are some examples: caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. So major bodily function, it's includes but it's not limited to functions of the immune system, normal cell growth, bladder, all sorts of um, all sorts of major bodily functions included. So if you need help doing any one of these activities, that is if you have a substantial limitation, which will be explained in the next slide. Under the ADA, you have to have a substantial limitation on a major life activity, which is the inability to perform a major life activity in the way that an average person in society would be able to perform it. Cancer can be a disability under the ADA, but it is determined on a case-by-case basis. Disability is not just the diagnosis or illness itself, but also the side effects of treatment. Cancer is as individual as the person. Not every diagnosis is the same. Not every prognosis is the same. So depending on whether you are in the course of your treatment or recovery, where that process is for you, cancer may be considered disability. It's hard to imagine that it wouldn't be a disability, but it's a case-by-case determination based on various factors. How severe, how long is the impairment going to last, how does it impact your life? That was the definition of disability under the ADA. As I mentioned, you have to know the definition of disability so you know what protections you're entitled to under various laws. There are state laws that provide the same or similar protections to employees. ADA is a federal law, but depending what state you're in, you might be entitled to protection under your state law as well. Especially know this information if you don't work for an employer of 15 or more employees. And as you can see, some states don't require 15 employees. Some states may include cancer as a disability, and some states do not require substantial limitation. So there are all sorts of different categories that states might be helpful for. People often ask whether they should let the cat out of the bag. In other words, to disclose or not to disclose a disability to an employer. This is a question that we often receive, and people ask, you know, do you tell your employer about your disability? Do you tell your employer whether you have cancer? Ultimately, the decision of whether to disclose is entirely up to you. That's what we always tell folks. So we're saying that to you as well. It is your decision. The decision may be framed differently depending on whether you have a visible disability or a non-visible disability. Some choose to disclose to be fully transparent and eliminate the element of surprise when needing time off later, and others choose not to disclose because although discrimination in the workplace is illegal, the unfortunate reality is that it still happens. So these are considerations to have. Consider whether you will need a reasonable accommodation to your job and whether you need time off. The Department of Labor website offers some things to think about in weighing your decision, but ultimately it is up to the individual. The point is that there's no right or wrong answer. It's what makes sense for you. Okay, if you have a disability and are a qualified employee under federal or state law, you may be entitled to a reasonable accommodation. What is a reasonable accommodation? Any change or adjustment in the work environment or in the way things are customarily done that enables an individual with disabilities to enjoy equal employment opportunities. It applies to all terms and conditions of employment, including benefits. An employee might need a reasonable accommodation to have equal employment opportunity. So, what might be a reasonable accommodation if you're a cashier who stands all day for work and experiences fatigue? As a symptom of a disability, you may ask for a chair or rest breaks. Accommodations must be reasonable. That is, if the employer should accommodate unless it's an undue hardship. Undue hardship, significant difficulty or expense in light of the employer. It's a case by case basis. So let's go back to the cashier who might need accommodation for his or her fatigue. She can ask for a chair, but can't ask for an office and a gold plated luxury chair, right? It has to be reasonable for both sides. First of all, an office for a cashier is out of the question. Cashiers have to interact with the public and operate a cash register, but the employee is entitled to reasonable accommodation. The chair is one thing. An executive office chair may not be the right accommodation. The employer can say a stool would be best because they need something that takes up less space, for example. Remember that employers must make reasonable accommodations. If you need time off and you're not eligible for FMLA or don't have any leave time, you might want to ask for time off as a reasonable accommodation for someone with a disability. Or if you are coming to the end of the 12 weeks allowed under FMLA and your doctor says you shouldn't go back to work yet, then you might ask for additional time off or an extension of FMLA as a form of reasonable accommodation. If your doctor says you need another week to heal and you ask for an additional week, that might be reasonable to ask the employer. Not necessarily a guarantee you'll get what you ask for if it's a few days or a week, but much more likely to be considered reasonable if it's a shorter time. So do keep that in mind. If your doctor says, I'm not sure when you'll be able to go back to work, but it probably won't be in the next few months, and you ask your employer to hold your job open for months or just indefinitely, they're probably going to see that as unreasonable. To hold your job open for such a long period of time, probably not. So let's talk about documentation of a disability. An employer may request documentation of a disability. We also get this question as well. If there is a request for accommodation, the employer must keep documentation confidential, and the employee does not need to specify cancer as a disability. We have a handout on our website that explains the difference in medical certification that may be required for FMLA versus ADA reasonable accommodation. Under FMLA and ADA, do you need to disclose the specific diagnosis? No. So long as documentation establishes that employee has a disability under the ADA and needs a reasonable accommodation. Our website has the handout that explains all the nuanced rules in detail and compares the FMLA and ADA rules for medical certification. So, if someone is on the job search, here are some additional tips. We talked a lot about workplace protections while you have a job. I want to talk for a moment about job applicants. An applicant with a disability, like all other applicants, must be able to meet the employer's requirements for the job, such as education, training, employment experience, skills, or licenses. An applicant with a disability must be able to perform the essential functions of the job. the fundamental duties either on their own or with the help of reasonable accommodation. An employer does not have to hire you if you're unable to perform all the essential functions of the job, even if you have, you know, even with a reasonable accommodation. So, however, an employer cannot reject you because the disability prevents you from performing minor duties that are not essential to the job. If you're looking for a new job and have a history of cancer, you may be wondering, such as, can a job application contain medical history questions? Or what should I tell my prospective employer regarding my cancer diagnosis? Or what can I keep confidential? So you never need to disclose to your employer that you have a medical condition unless you're asking for a reasonable accommodation or some other type of medical leave. The ADA prohibits employers from asking questions that are likely to reveal the existence of a disability before making a job offer, such as, during that pre-offer period. That includes written questions and inquiries during interviews. After an offer has been extended, but before the individual begins work, it's considered the post-offer period. An employer can ask questions and ask an employee to take medical exam as long as the employer asks those questions to everyone who's offered the same type of job. They can only ask that to people who have obvious disabilities. So we are the Cancer Legal Resource Center, and of course, we do provide resources. So we'll get to those resources in a moment, but keep in mind that national and state laws are just a baseline for protection that employers must provide. Sometimes employers provide more protection than the law requires. The places you can look for additional workplace protections include employment documents like employee manuals or union contracts. And check with people like your human resources rep or union rep if you're part of a union. Let's give you an example here to put it all together. So earlier we talked about John, of course. Now we're going to talk about Sarah. Sarah recently graduated from college and has been working part-time at a local law office for 2 months. 2 weeks ago, she was diagnosed with cancer. Last week, Sarah told her supervisor that she had been diagnosed and will need some flexibility to get treatment. She will still need to have some time off. So let's see here. She's only worked for 2 months. Does that matter? No, not for the ADA. Anti-discrimination law even applies during the interview. She can ask for reasonable accommodations, for example, a chair. She can ask for nap breaks. She can ask to take some time off. She can ask to work from home. So, pop quiz for review: would FMLA apply? So, Sarah's worked at the company for 2 months part-time. She can't get FMLA because she hasn't worked for over 12 months and hasn't worked 1,250 hours this week. The employer equals 50 plus in 75 radius, 200 employees. So a reasonable accommodation could be an extension of leave time. As shown in this slide, you can still be terminated for performance-related reasons. Practical tip: you can request accommodations before your work performance is affected. A key part of this: having a disability doesn't entitle someone to indefinite protection. It does not mean that you automatically cannot be fired for any reason. It simply means you can't be fired for discriminatory reasons. So you can be hired for performance-related reasons. This is why we tell people to ask for accommodations before their work performance is affected. If an employer sees you sleeping on the job, you can be fired. If you tell the employer you have a disability that causes fatigue and you'll need to take frequent breaks or work less hours, then they have to engage in the interactive process to come up with an accommodation. Once you tell the employer you have a disability, they're on notice and will need to work with you to come up with something to help you. What happens is a lot of people don't want to tell their employer out of fear, and they slip up at work and can't do what they once did to the full extent, and they're terminated. Saying, wait, but I have cancer after you're terminated does not do anything for you. As I said before, we are the Cancer Legal Resource Center. So, of course, we want to make sure to provide you with resources. So, as you can see on this page, and I'll wait a moment just in case you do want to jot things down in real time for some helpful resources. And again, we are recording this presentation so you can go back and write the specific websites down. Here is another page of resources, as you can see on your screen. So I'll pause for a moment to enable you to take it down if you wish. All right, well, thank you so much. Thank you for participating in this presentation. Please remember that if you have any questions that are specific to your situation, you can call the CLRC or fill out an online intake and we will get back to you. As you can see, we have the website on your screen, and as well as the link for an online intake and also our toll-free number. You don't have to call both, just either fill out an online intake or leave us a message. One will suffice. And now I'm going to actually stop the recording and take time for questions. So if you have any questions or comments, now is the opportunity to ask them.